down with OTC? Down with OTC. OTC. Are you down with OTC? Are you down with OTC? OTC. Are you down with OTC? Down with OTC. Down with OTC.
Hey, welcome to On the Chain. This is Jeff here with co-host Chip and our special guest, John Deaton, attorney at law, taking on the SEC. Welcome, John.
Thanks, guys. But just remember, I'm not doing it by myself. I've got 10,700 people right.
Man.
I won't even say behind me, right next to me.
That's big. That's a big number. All about supporting the community, the XRP community, and really the crypto community at large by this overreach by the SEC. And we've got a lot to cover. There's some new news that John has to share with us. We want to dig in, talk about that, and a lot more. Chip, let's kick this thing off.
Are you down?
Ready?
Welcome to On the Chain with Jeff and Chip.
Yeah, welcome back. Welcome back, man. John, it is awesome to see you again. You know, every time you come on, it's because there's new news, and it's awesome.
Well, listen, I told Chip this when I was out there and tweeting away about government overreach, and no one knew my name really. You guys were like the first ones to reach out and say, hey, maybe this guy's got something to say that's worth listening to. So I always have a sense of loyalty with you guys and On the Chain. So anytime there's new information, I'll be more than happy to share it with you.
That's awesome. Yeah, we appreciate that. Yeah, and then somebody put a bet. Somebody has been spreading some rumors about a bet that I would shave my head if we got 500 likes. Well, I would love 500 likes, but don't get me wrong, but no.
And you love your hair a little bit more than that.
I do. I mean, my God, I do. I really do. And
I got news for you, Chip. I love your hair more than 500 likes.
Well, there you can see it right there, right from John E. Deaton. And the reason we like to put John E. Deaton because it's like Johnny, yo, Johnny. You know, it's like John E. I love that, like Johnny. Beautiful, Johnny. So there's some good news going on today. I mean, some positive news came out today. You want to share a little bit from your perspective on the news?
Well, yeah, and I also want to make sure that people don't misunderstand it. You know what I mean? And so basically, the judge has granted us what's called leave, which means I can file the motion. She had the decision. I sent the 4-page pre-motion letter. Ripple responded. The SEC responded. Ripple took no position, but said we think they should be allowed to at least brief it. And the SEC, of course, objected to it and said that we shouldn't have any right to brief it. And the judge disagreed with the SEC, and she's given us the opportunity to fully brief it. And hopefully I'll be requesting an oral argument when I file the papers, and we'll have an opportunity to be heard, not just on paper, but also at an argument. And, I personally looking forward to that if it happens.
Oh, hell yeah. I think everybody's looking forward to that. So I just wanted to say a couple things here. So the Speedboat says, oops, sorry about that. Speedboat, good evening, guys. Thanks for being here, John. And we also have Andrew Handelman says, John is fire.
Well, thanks, guys.
Pure fire. So that's awesome to hear.
But, guys, let me make sure that people don't misunderstand it.
Right.
The motion to intervene hasn't been granted.
Right.
What's been granted is the ability to make the motion. So it's one step at a time.
But it's a good first step because the judge could have shut it down. I mean, based on yes, like you said, Ripple took no position, but the SEC, well, that was a shocker. Would that come as any surprise to anybody that they didn't want you to intervene? I mean, the XRP army to kind of like come in? No.
Yeah. Well, the SEC keeps surprising me a little bit because, and maybe I'm even still a little naive because I thought, well, maybe the SEC is going to clarify and say XRP, the token itself, which is akin to the oranges. If we go back to Howie, right? The token itself is not a security. We're only claiming the way that Ripple sells it is a security. That's all they had to do. If they did that, then even Ripple said, if they make that clarification, then XRP holders have a limited role in this litigation, if you will.
That's interesting, John. Is that similar to the outcome with Kin and the Kick token?
What do you mean? Like,
well, they said that the organization was selling a unregistered security. Right. They pay a $5 million fine. However, they didn't rule whatsoever on the retail aspect. They left that out of the equation altogether. It never came up in their ruling, to say, well, if retail is selling or exchanges are continuing to sell it, they just ignored that part.
Well, right. And this is what makes it different. And this is what I've been saying from the beginning, which is the difference here is that they're claiming that present day XRP, without limiting to Ripple, is a security. Now, in their papers, they go back and forth. They'll say, oh, this is just a strict liability case, and it's whether or not the way Ripple sells it is a security. But then the next paper they file or the next oral argument they give, they'll stand up and say XRP has no utility today, and it itself is a security. But I agree with you. If they would have continued to prosecute the case the way they historically have, including Kick, then I wouldn't even be here today because they can still take the position that even today, when Ripple sells it, it's a security, right? They could take that position and then they can fight Ripple on that. I'm not saying they'll win, but they can make that. But what they're trying to do is hold everything back. Ripple had a sentence in their brief, and they talked about optionality. What they were saying is that the prosecutors want all options. They want to be able to say that the token itself is a security. They want to say that when Ripple sells, it's a security. And they don't want to make that distinction. And all we have to do is look at that March 19th transcript where Judge Netburn asked that question. And the SEC's attorney goes on record and he does that dance, right? And he says, oh, well, I'm not saying that anyone in the world that sells XRP is selling, is a violation of Section 5 of the Securities Act. It's just the way Ripple's doing it and its affiliates. And there's exclusions under Section 4. And now if you don't know securities at all, that sounds like, okay, well, there's exceptions. Sections 4 only apply if it's a security. So, you know, bunch of lawyering, dancing, and then if you look back at later in Ripple's Solomon's answer in response to that, he says to her, no, despite what the SEC attorney's saying, it's still on the table that a retail investor holder could be alleged that it's a violation if they sell it. And so I think the SEC is making a huge mistake, because just get focused, you know, focus on what you can prove. Focus on, hey, I think that, you know, Ripple in 2016 or 2015, when you sold it to this investment firm or this venture capitalist, that was a security. All right.
Exactly. Yeah. So we talk a lot about XRP, right? We talk about XRP being, you know, the use cases. You put that amazing tweet out there, and I loved it because you were asking people to weigh in on different use cases that did not specifically rely on Ripple. And now here is the prime example. This is James Rule, XRP, sending us a $14.99 tip. How is he sending that? Well, he's using his Uphold MasterCard and using it to send. He's actually using XRP to send, as, you know, there's a use case for you right there. So I thought that was completely amazing. Thank you for that. Really appreciate that. James,
Chip, he followed it up with this.
Oh, sorry. Go ahead.
Hang on. He followed it up with that right there. I just tipped Chip and Jeff with an unregistered security. So now it's come down to that, right? There's a, you know, unknown variable in the community. So Chip saying, you know, James has his XRP, he's the MasterCard. On his end, he's using XRP. Obviously, it gets transacted over to YouTube in fiat. But at the end of the day, there was a transaction with a supposed unregistered security per the SEC's claims.
Yeah, touche, James, by the way. And John Doe, thank you for that. Really appreciate that super sticker. Pretty cool. Yeah, it's amazing, this whole thing, man. The whole thing is just...
The other thing I want people to really appreciate is that if you don't, you guys recall, I don't know if it was a couple weeks ago or 3 weeks ago, there was all that FUD about how we were running out of time. Remember, I came in and I was like, hey, here's a case that, you know, a year after or 7 years after, and you're like calming me down. It's like, okay, John, you're saying we got enough time.
So, yeah, we got a little runway, a little bit of runway.
Right. So the bottom line is just stay course. Like, you're going to hear these articles or these opinions, and people are going to spread the things that they're going to spread. I mean, some of these Cointelegraph articles or others, it's just, I can't believe how wrong they get it. You know what I mean? I'm surprised they could spell my name correctly.
Well, they do get a lot wrong. Hey, by the way, I want to do a big shout out to Tony at Thinking Crypto. He did an awesome interview with Tony, and Tony's a great interviewer. I mean, he's putting out some really great stuff. So, you know, I just want to do a shout out to Tony. Nice work, Tony. Very well done. And yeah, there's a lot of fun. But, you know, funny thing is almost you can't rely on almost anything they say. And it's not just one publication. I know they get some of the case issues wrong, but I'll tell you, a lot of times they get a lot of things wrong about a lot of different digital assets. They say the wrong thing, they confuse them with other things, but they're rushing so fast to get these out there for clickbait. You know, they're running out there trying to get these articles, and people are sharing them all over Twitter, and it just makes it compounds it all. And then people start believing a lot of the garbage in there. But then we have to rely on you to throw the a little bit of hot water, or cold water, I should say, on the FUD, and knock them down a few pegs. Like, you know, you tweeted, there was that article last week where you had to just like say, what is this?
Right.
It's insane, these people.
Well, and also sometimes even if they're reporting correctly, the underlying statement they're reporting on might not be. I mean, look at what the SEC attorney said about me, where he said that they literally said that the motivation behind what I'm doing is simply to get the exchanges to relist it because I believe it will double and then I can sell for a profit. I mean, they literally said that in a court document to the judge. And I remember sitting there saying, God, I never talk about the price of XRP. It's just something I don't do, right? I don't know what the hell is going to happen to the price. And I went back and I looked at it, and I literally was trying to explain to people in a reply where I said, listen, don't count on the SEC to give you the clarity for the exchanges to relist. And then I just made the comment. I said, on top of that, if the SEC said, yeah, you can relist XRP and XRP happens to double, then Ripple would have twice the amount of money in escrow to fight the SEC. I mean, that was the comment. You know what I mean?
I got a little bit mixed up there, but that's funny when they say that. So Rob XRP is chiming in here. He says, thanks for fighting for the XRP community. You're writing our history. Thank you, Mr. Deaton. My future generations will thank you also. And then also Reg Mabry. It's so spot on, man. You're right. You are writing. And the funny thing is, your name will be in the history books, right? So your name is going to be there with the XRP, the 10,000, 10,800 are going to be there together. And we know that there are tens of thousands, if not 100,000 plus, that are standing in line behind them, all rushing the forefront. We have, you want to take that, Jeff?
Go ahead.
Reg Mabry says, John Deaton, thank you from an XRP investor whose IRAs have blocked me from withdrawals. This is great news. Can you imagine that? His individual retirement account, if you're not familiar with what an IRA is, have blocked him from withdrawing his funds. Yeah. This is insane.
No, it's unbelievable. And as I've said, there's so many of those stories out there. People have just, busted their butt. They've done a diligent research, some of them, or a lot of them, and they think they made the investment, and then the government steps in and pulls this stuff, and it's just not right. And so when Tony was asking me, why I filed the lawsuit when I was interviewing with him, and I said, listen, as soon as I read to the present, and they didn't distinguish between the token itself, it was like, this is just going to be a nightmare. Of course, I underestimated. I didn't know how many stories out there of people's life savings would just completely be either, squandered or held in purgatory, as the last person's comment was. He's just sitting there. He can't do anything with it. His IRA, I don't know how old he is, but let's assume he's my age. Then that means he's got what? He's put in 20, 30 years of earnings into his retirement account, and it's being held up and it's frozen. I mean, that sounds like a third world country to me.
It does, man. I mean, it's getting to a point. You see what they're doing now up in the New York area, where they're, rolling out these health passports. They can control the ebb and flow of the movement of their people. They're building that on blockchain technology, which, this technology could be the greatest thing, or it could be the worst thing. It depends whose hands you put it in to develop the outcome. And we're seeing this exact same thing. The influence by the SEC could be a good thing and do what it's supposed to do, which is uphold and support the investor, or it could be a bad thing where they're doing whatever is politically expedient for whatever their, desired outcome is. Nobody really knows what the SEC's desired outcome is, based on the politics of it. But it's the people that end up, suffering. And so imagine right now, had you not filed this case, I think this gives a lot of people hope, for an outcome that their voice can also be heard in this scenario, that the SEC can go after Ripple, and we'll see it on the front page news. And it's one Goliath after the government, and they're just going to fight it out. and wherever the cards fall, they'll fall. But man, this is, and we probably said it before, but it makes just a major, major impact.
Well, the problem is in that war, who's the collateral damage? It's the regular investor. Correct. You know, it's the person that's got $5,000 because that's all that they could put in it, and they had $5,000, and they put it in XRP, and that's all the money that they've been able to put together, and they're the victim. Or it could be the person with a lot more than 5,000, and they're the ones. The billionaires will make it. They'll be okay. And the government employees, after they make their little alleged public service, then they'll go on to work at the hedge funds or the Apollo group or what's Clayton doing now? He's now involved in cryptocurrency, right? The guy that didn't really support it.
Yeah, where'd he end up going? Chip, you were talking about that earlier.
Yeah, I was talking about that earlier. I'm trying to think of the name of the place. It was one of the stories we had on tonight. I just queued up something else. No, but this company basically really bet big on Bitcoin and Ethereum. That was the two things they bet big on, right? So like $1 billion in it. And all of a sudden he ends up there. Yeah, One River it's called. So he took an advisory role at One River, and that was what they had plans to purchase $1 billion in Bitcoin and Ethereum. That's not a conflict of interest, right? But something that you brought up, John, maybe you can elaborate a little bit on it. But in one of your tweets, because I've always wondered, you had Hinman. It was at some kind of a Yahoo conference. He's given a speech, and he kind of like throws in there, like off the cuff, like, well, and Bitcoin and Ethereum aren't securities. But there's no like official guidebook of the SEC where it's noted. It's like, oh, he gave the blessing in a speech, but where does that? And you brought this up that isn't law per se.
No, absolutely not. It's just statements. And let's not forget, every time Hester gives whether it's Tony's Thinking Crypto or whether it's any other event where she speaks, what does she say? And I'm not criticizing her. I'm just stating what she says because she has to, which is, all right, I'm just giving you my opinions. You can't bind the SEC based on what I say. My fellow commissioners, it has nothing to do with them. The SEC publishes a risk alert, and what does it say? It says this guidance, these statements that are being made by the SEC are not being approved by the SEC, and you can't use this against the SEC. This is just SEC staff trying to give the community some guidance. I mean, what is that? So like they're able to constantly not take a position. You know what I mean? So it gives them the options to basically do what they want, when they want, and how they want. I mean, Bill Hinman in June of 2018, he's not even in enforcement, right? He's the director of corporation and finance at the Securities Exchange Commission. He gives a speech how he met Gary. And in it, he just gratuitously says, hey, Bitcoin, not a security. Ethereum, well, if you ignore the initial offering, it's sufficiently decentralized now. It's not a security. And then he does his stint for 3 years. He refuses to give any guidance on XRP. Jay Clayton then goes and he gets interviewed by CNBC, Glenn Hutchinson, everybody. And he's constantly asked, well, that guy, Bill Hinman, said that Bitcoin, Ethereum's not a security. What about XRP? We don't make comments. We don't give comments. And then after 3 years, they leave. And then you get the Skybridge ETF for Bitcoin. And in the application, they literally say what? They say, hey, senior leadership at the SEC, it's my partner who's 2 doors down from me, named Bill Hinman when he was there. We're using that as proof that Bitcoin and similar cryptocurrencies are not securities. It's just this complete circular door of corruption. This is how I look at it. It's just a circular door of corruption.
You think some of that will be on term? I mean, I think the more, one of the things that I don't think that they underestimated was the fact that this community is filled with researchers. We've been researching digital assets, and it's funny, you had already uncovered some of the nastiness that's going on behind the scenes, but Bill Hinman getting $15 million from the law firm, and and then it's all come to the CCP, and there's all kinds of weirdness going on behind the scenes, and you kind of, after a while, you go like, okay, we kind of like expect it to be something like that. It's not a long stretch. I mean, you've been very vocal of your critiques of the government, and they're corrupt on both sides of the aisle. They're just deep corruption. They give the lip service, and then behind the scenes, they're slapping each other on the back and basically giving it to the people, right? So this is a lot of what goes on behind the scenes.
I mean, listen, the bottom line is I'm never going to criticize someone. He works at a law firm. He's working for the government. He's going to make $15 million because it's part of his, pension plan and all that. Hey, make all the money in the world, man. Like that doesn't bother me. What bothers me is that you should not, if your firm is part of the Ethereum Alliance, which is pushing the adoption of all, networks to be applied on the Ethereum blockchain, if that's their goal, then don't give up and give a speech that Ethereum's not a security. Like, just stay silent and collect your money. But instead, the appearance of impropriety can get to the point where it's just impropriety. Like, there's no dot connecting, there's no conspiracy theory. The appearance becomes so bad that it's almost presumed that it's corrupt. That's how
you see it a lot, John. I think that it becomes like an accepted norm, unfortunately. Yeah. So what he's doing is, and maybe, so in some cases it's very much out in the open like that. And others, they do whatever they do. They finish their service as an elected official or as an appointed official, and they always go off. They always end up in some category of which they had influence over. Right. Whether it's lobbying or, in this case, a crypto firm, and all of a sudden they're getting the big checks, and it always seems like it's a little too conveniently close to being a payback for whatever they accomplished during their tenure.
Yeah. Well, I mean, how is it possible that no Bitcoin ETF is going to even be seriously entertained by the Securities Exchange Commission from 2017 to 2020? But now, after Clayton and Hinman leave, we're looking at an ETF for Bitcoin, and their firms are involved in it.
Yeah, a little bit weird.
So it's just, the guy who was allegedly anti-crypto was the aggressive ICO prosecutions of 2017, right? Everybody said now he's an advisor to crypto.
Exactly right.
Exactly. See it all over and over.
XRP Hollywood says Jay Clayton and the SEC ruined my Christmas. I'm pissed. Christmas also happens to be my birthday. They ruined my birthday too. Thank you, John. So look at that. You got a double shot right there. I got a buddy who's born on Christmas too, and he's like, I'm like, you and Jesus, man. Two big dogs there celebrating your birthday, right? So So next steps, right? So you have a period of time. You have until when? You have April 19th is when the proposed, and you have to file your.
I'm going to have to give a plug. I'm on Crypto Law, right?
Yeah, Crypto Law. By the way, we have the tweet actually. I have it pulled up here. I actually have the Crypto Law up here. Well,
the reason I'm doing it is because they gave, I'm really honestly looking at it because I know that they tweeted out for me the dates. So April 19th. Right, April 19th.
There it is.
I have to file the formal motion, which will include a memorandum of law that goes with it. And then after April 19th, May 3rd, the SEC and Ripple can give a reply. And then I get 12 more days, and I'm allowed to respond to their reply.
Both parties get to respond.
Right. No, both sides get to respond, and
intervening.
I would imagine that Ripple now, listen, I can't speak for them at all. I don't talk to them, so I have no idea what they're going to do. But I will tell you this, that they said, we don't know what position to take, and we're not taking one until we know what the SEC is doing. But now, and you got to remember, Ripple was writing their response to our pre-motion letter at the same time as the SEC. They didn't get to see what the SEC was going to claim. And since the SEC did not limit their focus to just Ripple sales, I would imagine that that Ripple would become a little more supportive, like they said in their paper, that if they're going to claim that the digital token itself per se is a security, then these 10,755 people, they should be heard. And if they don't, and they're going to limit it to just our cells, Ripple cells, then, maybe they could be this elevated amici status and participate, but they won't be a party. You understand what I'm getting at? I might have went over.
Absolutely.
I may have got a little bit in the weeds about what's going on.
No, I think it's spot on. So Pat Prog says Deaton, the greatest of all time. That's what GOAT means. But if people go, the GOAT, wait a minute. No, the greatest of all time. So that's pretty cool to see that. And someone else said this. Oh, there's a funny comment here.
Thank you.
Someone said One River is foot if Clayton is advising them on crypto. So that was XRP panic there. So I thought that was pretty funny. Also, yeah, put that one up, Jeff.
That's Oscar Morrison. He's coming in from Iceland. So those are
Right.
Icelandic krona,
Yeah.
750. You got remember to visit crypto-law.us.
And guys, by the way, you can go follow John on Twitter. He's in the description. We have not only that, but also Crypto Law. You can follow them on Twitter, and then also we have the website crypto-law.us. So you can go out there, and you want to follow both because you're going to be the first to know when all this stuff breaks. Set yourself an alert. If you guys don't know how to do this on Twitter, it's like a little bell there too. You click that bell. So anytime I have John Deaton on bell, there's a couple people I have, and every time he tweets something, he's always like, why is Chip always responding to my stuff? Because I got him on, as soon as he tweets something, boom, I get the notice. So I'm like clicking on all the time. I want to know what's in the know. And also crypto-law, I also have the bell on too, because those to me are the solid ones there.
Yeah. Hey, John, look at this comment. I think it's pretty spot on. If the UK did the same as the SEC and 90% of the asset holders were U.S. citizens, the U.S. government would be jumping up and down crying foul.
Oh, yeah.
What are your thoughts?
No, spot on, 100%. And that's the other thing that needs to be taken into consideration. I don't think that XRP has ever been higher than 20% in the United States as far as volume sells. Maybe you guys know, but I've seen it. It's usually 80% or 90% is outside the United States. And so it is absolutely, it's got to be infuriating. You're over in Iceland or anywhere else in the world, and you see these other governments, the UK, Japan, Switzerland, they're coming out, they're trying to give guidance, they're doing the best they can. And then the United States is just absolutely holding your asset hostage for political reasons, for personal reasons, for whatever reasons, but it's certainly not for investors' reasons.
Yeah, here, look at this one. Dot column. The U.S. Securities and Exchange Commission has filed a lawsuit against New Hampshire-based crypto startup Library, accusing the company of selling unregistered securities in the form of its token. So here you go. One by one, they're coming after them.
We had Jeremy, the CEO and founder of Library, on here, and also all of our content is over there on Library. So now what does that mean? So everything that goes up here goes up over there, and they do have a token. They do have a way for creators to earn as well. But Jeremy came on here. They've been at it, Jeff, for a couple of years now. So now they're what? They're getting into this whole litigation.
So that's
with everybody enforcement.
Just getting started.
Oh, listen, if they're successful, if they were to be able to get their way with what they want to do with XRP, then just line them up. Cardano, XLM, Algo, they all just might as well just show up at the SEC because the SEC is coming to visit them.
Yeah, exactly. And there was a great video that Mickey B. Fresh put out He said you'll be furious when you watch Jay Clayton and what he said during a fireside chat with former SEC official to an elite audience of attorneys at the Bar Association. This was back in 2018. Clayton and the SEC 2-year investigation was intended to bully Ripple into registering with the SEC rule over Ripple. I want to play the video. It's got really low volume. I don't think it's going to come across very well. I mean, I can give it a shot. Basically, what Clayton says, somebody from the audience asked a question. Obviously, we're dealing with Bar Association. We're probably dealing with all attorneys. They crafted a question saying, well, what about companies that are leaving the United States because there's unclear regulatory clarity? And Clayton's like, with his like smirks and everything, and he says something to the effect of, well, you know, if you don't like our style of how we do it here, go ahead, leave. That's what he said. That's what he said. Go ahead and leave. I mean, what
amazing.
Well, he made that a crazy statement to Bob Pisani, where he said the United States was the envy of the world in securities laws. And it's like, are you kidding me?
The envy of the world.
Whose world?
Which world? That might have been Clayton's world right there.
I mean, listen, the problem is if Congress doesn't act, well, then we're forced in the court system. And what we're trying to do, just so everybody can, because I've never really sort of explained it in great detail. But what we're trying to do is, assuming that Congress isn't going to act, the SEC has basically said, look, the Southern District of New York is going to decide whether XRP is a security, and it deferred it to them. So we dismiss the writ of mandamus and we go to the Southern District and basically are going to be asking the court for what's called declaratory judgment or summary judgment, where basically she will declare, all right, that as a matter of law, XRP, the token itself, is not a security. It can be used as a security by Ripple or anyone else, but itself is not a security. Just like Howie, 1946, the oranges were not the securities, right? It was the way that the orange groves were packaged, marketed, and sold that was a security. And so that's the whole issue. And if we get that, or if the SEC sees the writing on the wall and then they come back, this will be another opportunity for them to clarify and say, okay, we're not claiming XRP itself is a security. Then we'll get clarity. Then the exchanges can go back and relist it, and Ripple and the SEC can have their individual fight.
Exactly. One of the dissenters in that case, the Howie case, dissented because he said that not all of them, not all the people that were offered the land, some of them went and actually checked it out. So he said that wasn't 100%. He also said that one of the reasons he dissented too is because some of the people, I think we're like 14 out of the 50 that actually worked the land. Now, don't quote me on the numbers, but actually went there to work the land. So he said, well, how is this going to be a global thing? It's one thing. So, I mean, it wasn't 100% provable, right? So not everybody, so you look at the investment contract aspect of it. Yes, they said they'd work the land. They didn't have to do anything. That's kind of how they promised it. That's how the Howie company, Orange Grove, promised it to people. But some people did go work it. And some people said, we'll take it to our own market. So it wasn't necessarily, so it wasn't 100% that it went in that favor.
No, you're right. And, you know, I'm looking at the transcript of the March 19th hearing. And just so you know that people understand, because people were saying, oh, I don't think the SEC is taking that position. He literally said, this is the SEC's attorney, now the court referenced utility for XRP. We dispute whether that utility actually exists, Your Honor.
Yeah.
Basically, that's the SEC saying that the XRP itself does not have any utility. And if they take that position, I've become more and more confident that we can be successful in the intervention.
Well, did you notice something else from that hearing? So another thing I noticed from that hearing was there was another point of that where the SEC attorney, Tenero, says something to the effect of, well, they sold it overseas because it wasn't easy to sell. I mean, because you couldn't, he kind of tripped up on that a little bit, but then he kind of circled back saying, well, Yeah, it wasn't an easy thing to sell, and you couldn't sell. So he's almost making the case that because there had value to it, they were able to sell it. Because you remember in that hearing when they got into the weeds about, well, she's asking, well, why do you need this? You're not alleging fraud here. The judge was saying, you're not alleging fraud. Why do you need the specifics? And they're more than cooperative to give you everything you're looking for. And it seemed a surprise to the attorneys as well, saying, well, we had these pretrial, conferences. Just let us know what you're missing. And then they got a really nice shot in there. It was one of the attorneys. I don't know if it might have been Solomon who said something to the effect of, well, you guys had, I'm trying to think what the exact quote is. Kind of got a little lost my train of thought here, but there was a really good dig that that he got in there about the SEC and sorry, lost that train of thought. Happens.
Yeah, it happens to all of us. But,
Yeah. So John, it really seems like, you've got the SEC running around, they're kind of bumping into each other. They don't know which way to go on as it relates to this technology. And they're kind of feeling themselves out. You bring up U.S. Congress, and so you go to the Congress where this legislation should be passed, and it's been brought in front of them multiple times. Yet they're bumping into each other because the majority of them don't even want to take the time to understand it. So you bring up a good point. It falls to the court to really decide, and once it goes in and becomes case law, then it changes things dramatically. But here's a comment here from Jason. He said, John, can you depose FinCEN attorneys since they already declared XRP a currency? So there's even dissension within government agencies as to what XRP is. Right. So how do you manage that part within an argument if you have one agency like FinCEN saying one thing and then you have the SEC trying to fight a completely different thing?
One thing I'm planning, as I was actually working last night on it, about, I think that the SEC's response, of course, is that currency is defined statutorily by the U.S. Treasury as being backed by sovereignty, right? It's sovereign currency, and therefore it's not a currency. But I think the focus needs to be on the word money, because the federal courts, including the Securities Exchange Commission, and I can cite the Ross Ulbricht case, all right, which I pulled the other night, and where the SEC says Bitcoin is money, right? So if Bitcoin's money, and it gives all these examples of how it's being used, and the court declared that Bitcoin was in fact money. And everything that court said, and there's several of them, including the Southern District of New York, about Bitcoin equally applies to XRP. But I think that, Jeff, I think you hit it on the head. I don't know if they fully understand the technology. I mean, do yourself a favor and read their letter to our motion one more time, like just having a cup of coffee and just take it slowly. And I'm telling you, you will be shocked at some of the things that are being said in there. I mean, they literally said that that because it is sold in the secondary market, right, that makes it a security. They said that proof, they literally said the words that move-ins, that's us, ultimate goal in seeking to intervene is for XRP to begin available trading again on digital asset platforms. And then they go, because that's the goal of the XRP holders, that proves that Ripple sold it as a security. Now explain to me how any other cryptocurrency doesn't match that.
Right, every one of them.
I mean, and when you read through it, it's like they're upset. They literally said the defendants offered and sold XRP as a speculative investment, and these XRP holders are seeking intervention so that the exchanges will relist it so that they can continue to try to sell for profit. Like, you could say that about anything.
Yeah, everything. What about gold? I mean, you could, definitely factor that into the gold exchanges. I'm investing in gold as a speculative investment because I believe it's going to keep increasing in value. And if you interfere with that, I'm going to say I want my gold to go up in value.
Name me one person that's bought Bitcoin that has not believing that it's going to go up.
But why is it
Right.
going to go up, though? It's going to go up because it actually has a use case. It has a functionality. It doesn't go up because I'm going to go Bitcoin, store of value, Ethereum, right? Smart contracts. But when you look at XRP, it has multiple use cases. The reason, as an investor, we're looking at it is because it actually has a use case. And this is where I really feel like the UK got it right. The 3 prongs, right? Could be a security, could also be a currency, and can have a use case. And I think that's kind of the right approach. That seems to me to be more metered and saying, well, it can fit into multiple categories. Let's not try to like find, cram it into the Howey test. That just doesn't work for a digital world, right? It just doesn't seem to carry the same sort of muster. What are your thoughts about where we go from here after this is all said and done? Do you think that Howey test is completely sort of, I guess, I don't want to say destroyed, but kind of put on the back burner when it comes to this digital world we're living in?
Well, I mean, I don't think that in order for the Howey test to be revisited, this case would have to go to the U.S. Supreme Court. And then you're literally talking 5 to 7 years from now. And so I don't foresee that happening. And I don't foresee the SEC ever giving guidance. I mean, they won't even commit to a publication or an alert. You know what I mean? They won't commit to anything. And so if Congress does not enact something and take control as they should, then this decision in the Southern District of New York is basically going to be the clarity. Now, that clarity may not be as clear as the UK's clarity. It may simply be we're going to go on a case-by-case basis, but the judge said the token itself is not a security, so therefore it could be openly traded in secondary markets. I mean, that's, in my opinion, that's the best that we're going to be able to get, absent the Congress acting. And that's why I've been pounding the table. It's why I started crypto law, was, trying to get, they need to get together, the exchanges, right? Kraken and Binance and Uphold, they all need to get together, hire a lobbyist who knows the ins and outs of DC, and put your money where your mouth is, and get to the educating these congressmen and these senators. That's the only chance that you've got. But instead, it seems to be everyone's on their own island, and well, it's not me. I'm not going to court. I'm not worried about XRP. My token is different, and your token isn't different, and that's what they need to understand.
Do you think the Token Taxonomy Act would be enough? Would that be sufficient? Because at that point, they would amend the Securities Act of 1933 and the Securities Exchange Act of 1934. They're seeking to, make some amendment, across the board, as they go into tax law, the IRS rule from 1986, and there's more. Is that enough to apply that to normalcy in the space as it pertains to XRP? Would that be enough?
I think, well, it's a lot more than we have now. I think until we have clarification of what government agency is going to be sort of the watchseer. I mean, so for example, who is in charge? Which government agency is the governing body of digital currency? Is it the CFTC? Is it the Securities Exchange Commission? Is it the Department of Justice and FinCEN? U.S. Treasury? I mean, who is our overseer? And until you have, I mean, how does the CFTC go after people for Dogecoin, saying that Dogecoin is basically being used as a commodity and it was a pump and dump scheme? Well, isn't that the SEC? I mean, the SEC is going after Ripple, saying XRP is a security. The CFTC saying Dogecoin to me is a commodity because they deal with commodities. And so it just seems like until there's that kind of clarity, you're going to have this intra-agency competition to basically get their claws in on it, right? This jurisdictional expansion, if you will. Now, I have it. Now, maybe they'll get together and say, okay, we can both pursue these under different scenarios, but that just leaves it way, too wild, wild west, and you don't know who's coming at your door. Is that the IRS? Is that the CFTC? Is it the Securities Exchange Commission? I mean,
you find it interesting, though. We have Gary Gensler, who's surely to be confirmed as the next chair of the SEC. Now, interestingly enough, he was nominated by Obama from 2000. He served from 2008 to 2014 as the CFTC chair, right? So it's kind of weird, the history, right? He was in a different government enforcement sort of body. Now he's very familiar with cryptocurrency. What do you think about Gary Gensler? Do you think he's walking into a landmine with this? And what do you think he's going to do once he is confirmed and sort of like walks through the proverbial doors one day and says, okay, I'm running the show now. What happens next?
I mean, I think one of the things that he's going to have to address is he'll be briefed on this case without question. If he's not being briefed, already, he's looking at a potential class action. Whether that class action gets dismissed later or not, they're looking at that. They're looking at the SEC and the XRP holders are in this huge, confrontation, if you will. If we're allowed in, I would expect that there would be a lot more publicity then, right? That the Securities Exchange Commission is objecting to the very people that they brought the case on behalf of. I mean, that's a very interesting corner that they're kind of boxed into. And so I think when he comes in, he's going to probably ask this question: how do we end this, save face to the extent that we can, and move on, right? Because do they really want a significant loss? If they lose to Ripple, then there's precedent, and then that gives even the smaller players a little more confidence, right? If you've got this precedent, even though you don't have maybe the deep pockets that Ripple has, you can't hire the 23 attorneys necessarily, right? But you have this favorable ruling that came out of the Southern District of New York. It gives you a little bit more like, okay, it's worth it now. Let's fight it. And then all of a sudden, the SEC is in case after case. They don't want that. Listen, it's just like any prosecutorial organization. Do you know that if in all the states, if all the criminal defendants said, I want a trial, I'm not pleading guilty, I don't care what the offer is, I'm going to verdict, it would bring the criminal justice system to a halt. Now imagine if everyone took the position when the SEC came knocking, we're claiming a violation. Okay, I'm fighting it. We could bring the SEC to a halt. And so there's a lot for them to lose. And I don't think that Gensler's a lot smarter than me, and he could figure out a way better than I could probably to come to a compromise that the SEC gets to keep picking the flesh that they want as they move forward, without taking a huge L. And I hope that's why I think the best thing that Ripple can do is just keep fighting exactly how they're doing, and we keep fighting for our interest and back the SEC down. Let's make them back down because of our offense as opposed to the defense.
Yeah, the SEC doesn't want discovery either, right? They don't want discovery. Right. These FOIA requests could be very damaging to what they're doing too. You see, they're going to put all kinds of guards up. Anyway, I thought I'd throw that in there.
One thing that I'm sorry. Go ahead, Jeff.
Oh no, just a quick question here from Ken. Could you reframe the form complaint to the SEC into a letter of intent to every congressperson in the United States?
Sure. And like get out like a mass type of notice. Sure, that's a good idea. Drawing attention. If we got enough people, pounding the table, there's strength in numbers, and so that's a very good idea. But I think that the industry itself needs to get organized. That's all. We've heard nothing from any industry, right? Player. whether it's the this association or that association, it's just crickets, silence.
That's true. Yeah.
And why, I don't know. You know what I mean? But look at the SEC right now. They're not very good at reacting, right? What's the SEC good at? They're good at intimidation. They're good at, we're coming after you. We're good at, here's 51 subpoenas to all your customers, all your clients. We want to know where, we want your wife and your kids' accounts, that you're the trustee. We want all of that bank information. Here's a big magnifying glass. Right now, we start filing things. They're not so good at it, right? Look how they responded to the writ of mandamus. Look how they responded to the 4-page letter motion with this nonsense, right? Nonsense, an avalanche, right? An avalanche of cases, he said, is going to come in if she allows us in. There's 5 plaintiffs. That's the avalanche. 5 plaintiffs, and they're claiming that XRP is a security sold by Ripple. So they can't intervene because the SEC is already making that argument. You know what I mean? And so they're just not good. They're reacting, and they're just throwing everything at the wall. And I think they're going to lose credibility each time they put their name to a document. Each time they open their mouth in court on the record, I believe they lose credibility because they have an unfocused approach to this litigation, and they're used to just making people submit, right? And Ripple's not submitting, and the 10,750 of us are not submitting, and we're going to see how it plays out. But you know, if we lose, we lose, but we'll be in the fight.
Yeah, but I think they're going to have a very hard time. First of all, they got to prove it, right? They got to prove it. Even when they amended the complaint, they started, I mean, they paid more attention to, let's add some more recklessly's into it versus, and let's inflate the numbers a little bit. Then, like you said, it would have been better if they had their case more focused. There's a lot of fluff in that case that has nothing to do with alleging the fact that it was an investment contract, right? And they sold an unregistered security. But I think the trap we are in right now is the fact that, well, what about today's present day? What about XRP in 2021? I think we're all pretty much safe and where would you say that we're safe in sort of assuming that today's XRP is not a security?
I've said from day one, and I'll say it on the record if I'm allowed. I do not believe that an SEC attorney can stand up in good faith and say, as an officer of the court, that the XRP in Jeff's account is an unregistered security. All right, unless Jeff, was sitting with Brad, and Brad, said, "Hey, I'll sell you some XRP," or so, unless some scenario like that happened, then they can't make that argument. And so, if they can't make that argument, then let that part of the case go. And there's this resistance to it, and I don't know why. I really don't. I used to be a prosecutor, and you think about these. I personally think they really messed up by charging Brad and Chris, and I'll tell you why. If I were sitting around the table at the SEC, not that I would, but if I ever was, right, and they brought this case to me and I got to give my input, I would say the following: either charge them with fraud, or we just stick to the strict liability of Ripple selling unregistered securities. Do not go down the road. If we don't have evidence of fraud, then why are we pursuing them? We have to prove now that Brad Garlinghouse and Chris believed it was a security, right? And we have to prove that they were reckless and they had this reckless disregard. And I got news for you. A letter from an attorney that says, hey, just be aware that in certain scenarios, it could look like a security. Well, shit, you can say that about everything, you can say that about anything. And so if that's the only evidence they had, they shouldn't have done it, because now there is a chance that the court will say, well, I'm not saying it's admissible, but I think they have a right to find out to why Bitcoin and Ethereum are not securities. They have a right to at least, go down that road. Maybe I'll exclude it later, But since you have to prove that they believed it was a security, then I think that the SEC's own debate about it being a security was at least might be relevant. They made it more discoverable, is what I'm saying. And so I think it was a huge mistake. But I would have said, hey, if there's no fraud, there's no fraud. Why go after them individually?
And that's tough too, John. I mean, how are you going to prove that they believed it was a security? There would have to be some sort of then intent to cover up the fact that they were selling a security, or there would have to be some sort of documentation to show that they had designed it as a security, or, you know, I mean, how would you prove belief versus intent?
Not just that, but, you know, here you put Brad on the stand, right? I'm Brad's attorney. I put Brad on the stand. I say, give me some of the reasons that you didn't believe that XRP is a security. He goes, well, you know, there's this guy, his name's Chris Giancarlo. He used to be in charge of the CFTC. He actually wrote a paper, and he stated unequivocally that XRP is not a security. And he's in charge of commodities. He's like the chairman of the commodities, right, in the United States of America. And he said it's not a security. So I relied on that. Like, he's an expert at it. I'm not. Boom, there's one. And then you go through another one, and then you go through another one, and then you pop in the videos where securities lawyers are being interviewed, and they're asked a question. Hey, do you think XRP is a security in 2017? And the guy says, no, I used to prosecute these cases, and no, it just doesn't meet factor 3 or whatever factor of the Howey test. Brad, were you aware of that? Yeah. Did you rely on that? Yeah. Is that one of the reasons you don't believe XRP is a security? Sure is.
The FTC, the Department of Justice, you know, they both said, referred to it as a currency. So also too, something Jeff and I have discussed here is, like, in 2013, go back to the beginning. Who knew? I mean, everyone has heard of Bitcoin now, but show me an attorney back in 2012, 2013 who knew, really understood. And again, this is right in line with the SEC today, understood what a digital asset or a cryptocurrency was. Of course, an attorney from them would say, well, you know, it could be a security. What do they know about a digital asset? Nothing, right? Do they know about a utility? Nothing. So it wouldn't be shocking for any attorney in 2013 to allege that. It might be more shocking in 2021, right, with what we know. So that's another sort of oddity.
No, you're 100% right.
Quick shout out to Doc Collum here for the support as well. And Doc Collum's been a subscriber and viewer of our show for a really long time. So it's always great when we have the old subs always participating here. Yep. What she said here, the craziest thing to me is the SEC saying XRP has no utility. And and you brought that up earlier, and with everything else, it just seems like, and this kind of goes over to Apex's question here, you know, do they really believe in what they're trying to promote in this case? Because here's Apex asked this question. He said, is it often difficult for lawyers to argue a case they don't believe in? Are they compelled by their conscience not to? So here they are, they give them a case, right? They say, hey, you're our attorneys, go fight on our behalf. And they're looking at this, and is that malpractice? Listen, how do you overcome that?
I mean, sometimes, you know, when I was a defense attorney in the Marine Corps, you know, I had a client, and he was a master sergeant of 30 years, and he was charged with using methamphetamine, and he denied it. And his urinalysis P-test came back positive, and he always denied it. Now, I thought he was guilty, right? To be honest with you, he went through a divorce and all that kind of stuff. He lost a lot of weight, but he always maintained his innocence. It was easy for me to defend him, and I won the case because what I focused on was the government's got to prove it, right? They got to prove his guilt beyond a reasonable doubt. And I talked about things like 30 years of service to your country. And so there's things you can latch on to, even if you don't necessarily believe in the case. But in this case, prosecutors fall into that. It's a competition. I want to win, right? And so Tenrero versus Solomon. And it becomes about that battle and not about justice. I mean, you represent the United States of America. That's got to mean something, right? Justice has got to mean something. The fact that there are thousands and thousands of innocent people who have been impacted and hurt has got to mean something. If all you're focused on is, I want to win this argument, so I'm going to say anything that I can, well, I have a problem with that. So when attorneys go, yeah, he has to make a case, but he chooses the words he chooses, right? I choose the words I choose, and you're driven by your own conscience in that situation. And unfortunately, the prosecutors who just want to win.
I agree. So I did remember what I was going to say. I'm kind of circling back to it a little bit, but I do remember the little tiny dig that I think it might have been Solomon. He said he was basically talking about Tenero. He said, well, probably you're not familiar with the case because you're not the one researching it. You're
Right.
simply the one litigating it. So you probably aren't as familiar with the case as you didn't do the research. I thought that was a pretty good line. It shows you the caliber of attorney when he's kind of putting that out there. They did a lot of that stuff where they throw it out there. A judge would like slap him back a little bit. But like you said, you can't unring that bell. It's out there. It's in the public, right? So I like that little bit of when he said that. I thought that was pretty good.
Well, to answer your question, Chip, you said, how do I feel about, 2021 XRP? So I'm going to read to you real quick what the Telegram judge said, right? And now Telegram, the SEC won that case.
Yeah.
But the judge said, quote, in the abstract, an investment of money in a cryptocurrency utilized by members of a decentralized community connected via blockchain technology, which itself is administered by the community of user rather than by a common enterprise, is not likely to be deemed a security under Howey. See that? So that's a case that the SEC won. But when you read that language, that's the language we're going to go before Judge Torres. And, we're going to be bringing that and saying, listen, he declared it. And now here are the facts. Here are all these 10,000 people and how they're using their XRP that, Ripple has no clue about. This is how the ledger, I'll get some expert affidavits, right, from people who are developers and how the XRP ledger works. And that it's, open and permissionless, and Ripple doesn't even know that you're using it, okay, necessarily on a given day, and get that all in front of her so that she can simply say, yeah, there's just no way that token today is a security. And if we get that from her, then we get the clarity that we want. Does the whole crypto community world get the clarity that it wants? Not necessarily, but XRP does, and then that's obviously very favorable, because then whatever Judge Torres finds and writes, then that'll be the guiding principle for all the other projects.
Got it. So DJ Jarvis says, hey, can you tell us and other content creators why it's a bad idea to replay clips of Ripple's public hearings, please? Because I do know that you did tweet about that. Judge Torres did get a little bit tweaked with the whole thing because the recordings were out there and making their way around. So what is it? What is it that it is public information, but hearings, I guess, is there something about the Southern District?
Well, it's just a rule, and they just don't want their rule violated. I mean, the reality is, if we weren't in COVID times, we could go to the courthouse and we could go into the courtroom and we would be watching these arguments live.
Right.
But they just have a rule that it will not be recorded and released to the public for whatever reason. There are times, and normally it wouldn't be done in this case, if there was something like that investor A would be called investor A instead of the name, right? So if there's something that's going to potentially be disclosed that the parties don't want, then they would do it in chambers and there wouldn't be an open public access to it. But, it's just the bottom line is it's a rule and they want their rules not to be violated.
Got it. So we want to make sure that in the community we don't do that. Martin Valk says, hey, thank you for representing all of us, John Deaton. You are a true gentleman. P.S. Jeff and Chip are not too bad either. So thanks for that, man. I really appreciate that, Martin.
Yeah. Hey, John, it was great. The hour flies by. It's amazing how much can be covered. Every time you come on, I felt like we just got started. But out of respect to you and your family and everybody else, I do want to, say, again, thank you for coming on, sharing your knowledge here, sharing your insight, but then also, leading the charge in this case, and like you said, there's 10,700, plus people, and many, many more that are behind this, in looking forward to, positive outcome. And it's, again,
Yeah, I mean, we have a long way to go, but we got to take our victories when we can take them. XRP holders, we all know there's probably no other holder of a cryptocurrency that has that's been through more, let's say turmoil, if you will. And so, we have a long way to go, but we got our foot in the door, right? It's one step at a time. Now the door, if we can just keep it cracked, the goal is to kick it in.
Yeah,
That's awesome.
no, I liken that to, I'll say my 2 bits. If I liken that to sports world, when you lose 4 Super Bowls in a world, it's really tough to be a Bills fan. So I understand that in many different levels, and it can happen that way. I just want to say, John, you're a warrior, and the community really appreciates everything you do. And I love the fact that you're doing the charge, you're leading the charge, but you have the support of this community behind you as more stories come out. So I just want to give you the last word.
I just want to continue to thank everybody. This community is amazing. It really is. From the very beginning, it's energized me. So I'm not saying it. I just wouldn't say it if it wasn't true. I'm getting as much out of this that I'm giving to people. You know what I mean? The love and the support and the encouragement. I mean, someone says something bad about me on Twitter or anything, and I've got like 50 people. I don't even have to respond, and I just, that kind of love and it does something. It changes you. You know what I mean? It really does. And that, I want to say thank you to everybody. I know everybody's saying thank you to me, but I owe them a great thank you too.
Thank you. Did we silence that scammer that was using your name and your likeness? And
I haven't checked today, but I sure hope so. I'd rather meet him in an alley somewhere, to be honest with you. But
do not mess with Deaton, man. He's got superpowers. Yeah. Don't mess with him.
Those people, it's amazing. Hey, for all those that are here, we have 500 plus in the stream right now. If this is your first time on the chain, make sure you hit that red button that says subscribe on it, sub to the channel, hit the bell notifier. That way you get notified every time we post a live stream. And we will have John Deaton back on because we expect more positive news as things progress. And I think that's it, because today's Monday. I keep thinking today's like midweek. I don't know. It's kind of a crazy time, end of the month, end of a quarter like this. But we'll be back on again tomorrow night, Tuesday at 8 p.m. Eastern Standard Time.
Yep. We'll see you on the next one, guys. Thank you.
see ya.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.